This is a public hearing of the Law Enforcement Conduct Commission in Operation Mantus, at which examinations of witnesses will take place during the week. Section 62 of the Law Enforcement Conduct Commission Act 2016 requires the Commission to announce the general scope and purpose of the examination as part of the hearing. I'll do that today, but will not repeat it each time there is an examination of a witness. The general scope and purpose is to investigate allegations that excessive force was used by a member or members of the New South Wales Police Force at a location in northern New South Wales in September 2022 during the apprehension and arrest of a young person, YPM1, and other issues arising from his detention in custody following that arrest. Are there any further applications for leave before I invite counsel assisting to address?
Could I just advise you, Chief Commissioner, that Mr Falzon appears for the Commissioner of Police today?
All right, yes. Thank you, Mr Falzon. Yes, thank you, Mr Fernandez.
Chief Commissioner, this is an update on the Law Enforcement Conduct Commission's investigation known as Operation Mantus. The investigation relates to an incident which occurred in September 2022 in northern New South Wales. The incident involved a young person known as YPM1 who was 14 years old at the time. He sustained injuries during the course of being apprehended by a police officer known as MTS1. YPM1 was treated by ambulance close to the scene and then taken to hospital where he stayed overnight. The apprehension took place at night. YPM1 was with other young people. Police were conducting proactive policing activities and they were in plain clothes. None of the police involved wore body-worn video. YPM1 says he was chased by the apprehending officer and another officer, MTS2. Officer MTS1, the apprehending officer, agrees he tackled YPM1 in order to arrest him. YPM1 says after being apprehended by MTS1, he was thrown on the ground and punched by MTS1. I should correct an error I made. YPM1 was not chased by MTS2. YPM1 says that he was later punched by another officer, MTS2. Officers MTS1 and MTS2 deny any punching. Because of injuries noted by ambulance officers at the scene, YPM1 was taken to hospital and was treated. He was under arrest. A series of private examinations were conducted on the 9th to the 10th of February and the 13th to the 17th of March. 13 witnesses gave evidence during the private examinations. I will summarise aspects of the evidence given by witnesses during the private examinations and advise of the evidence to be given in the coming 4 days of public examinations. Evidence given at private examinations. The following witnesses gave evidence at private examinations held on the 9th and 10th of February and the 13th through to the 17th of March. YPM1, Officer MTS1, Officers MTS2, 3 and 4, being other police who were present on the night in question. They were in plain clothes and conducting proactive policing in response to increasing crime in the location. Officers MTS6 and MTS7, who are in leadership roles in the relevant police district. Officer MTS8, the custody manager. Officers MTS9 and MTS10, the two police investigating alleged offences committed by YPM1, who interviewed him when he returned from hospital. Mr. Ron Frankham, Frankham, M, Head of Legal Aid New South Wales Children's Legal Service, Ms. Alex Burkett, Burkitt, and Mr. James Clifford, both from the Aboriginal Legal Service. They gave evidence of recurring issues relating to young people in custody being interviewed by police, even when the young person's wishes were not to be interviewed and those wishes had been communicated. During the private examinations, each police officer was represented by a barrister or solicitor. YPM1 was arrested by both a barrister and a solicitor. It is not automatic that legal representatives are given permission to ask questions of witnesses who give evidence at examinations in this commission. However, all representatives were able to make applications for permission to ask witnesses about issues they identified. Notably, YPM1 was asked questions regarding his evidence by a number of representatives. Background. Officers MTS 9 and MTS 10, both senior officers in the relevant police district, described the background as follows. The district covers a very large geographical area, and there are a large number of police officers and administrative staff. There are also youth engagement officers or youth officers and Aboriginal community liaison officers working within the police district. There are a number of discrete Aboriginal communities, as well as larger Aboriginal communities within some of the bigger locations in the district. Northern New South Wales suffered an extraordinary period of flooding in February and March 2022. Approximately 60% of houses were uninhabitable. 8,000 people were without a home immediately after the floods. More than 15,500 people were in evacuation centres across the region. They went into temporary accommodation in motels, caravans and Winnebagos. Police provided caravans and on-site caravan programs across the district. Police had to bring in demountables for temporary housing. A lot of people in the community who did not own their own homes were moved into what was called pod villages. Support services were stretched to the limit. In the first week after the flood, some towns were completely cut off by floodwater. Police had to use helicopters to fly in food and medicine. An Aboriginal youth strategy was underway by police before the floods. Police had convened the first meeting a week before the floods and were due to have a second meeting on the day of the first flood. The floods fractured communities as well, because a lot of petty theft or looting occurred. This had not been a major problem before the floods. In particular, property crime, break-and-enters, aggravated break-and-enters, stolen cars, steal from persons or steal from dwellings were taking place. They increased quite dramatically after the floods. Police stations in smaller communities were closed by the floods, so there was a significantly reduced local police presence. Police wanted to stop the offending, protect the victims, and make the community safe. A high visibility police approach was adopted, with a number of extra police patrolling at various times of the day and night. Police also engaged with the community to show there was a presence. Police also undertook a proactive policing approach in August and September of 2022. One part of this was a plainclothes police operation put together to investigate the offences and to identify and prosecute offenders. This strike force included a covert plainclothes operation to identify offenders. Police were expected, if they detected something, to act. This would not necessarily involve arrest. The action required would depend on a variety of circumstances. Body-worn video and how it was to be used was discussed by police in the lead-up to the night in question. This discussion included opportunities in relation to compliance checks, capturing young people police were doing bail checks on, and making comparisons to CCTV footage that police had previously reviewed or may capture in the future. So there were opportunities for investigation as well as checking on compliance. Although body-worn video had been discussed as part of the planning for the strike force, and in fact was carried by one officer on the night of the incident, it was not used. YPM1 says after being apprehended, he was thrown on the ground and punched. Officers MTS1 and MTS2 deny any punching. The dispute in the evidence will not be assisted by electronic evidence, as none of the police present on the night wore body-worn video. The night of the incident. Officer MTS2 was an officer in the New South Wales Police Force who had been stationed in the police district for many years. He was in the proactive crime team, which was focused on property theft, break, enter and steal offences, and cases based on forensic evidence, such as fingerprints and DNA. He was the senior officer by rank on the night in question. His understanding was body-worn video would be used whenever he used a police power, was involved in an arrest, patrolled a licensed premises, or executed a search warrant. These were the times police would most likely use body-worn video, and also when anticipating using a police power, such as during questioning or arrest. Officer MTS2 was not aware of any operational, practical, or other reasons why body-worn video would not be routinely used in his team. Each of the officers who attended on the night were in plain clothes. Officer MTS2 was with Officer MTS1, and the two other officers, MTS3 and MTS4, were together. Officer MTS2 took a body-worn camera and put it in his police car. He left it and his torch in the console, though, when he got out and started following a group of young people. Officer MTS2 described following the group and thinking they had entered a premises. He and Officer MTS1 followed them. Eventually, all four police came across the group of young persons. Those in the group, including YPM1, started running. Officer MTS1 chased YPM1. This was at around 9:45 to 10 p.m. The apprehension. Officer MTS1 gave this evidence. How long in distance did you chase YPM1 for? Oh, it was no more than probably 30 metres, I'd say. During that 30 metres, did you say anything? As he initially ran and I started running, I said, "Stop, it's the police." The name of the road, it's a 2-lane road, is that right? Unmarked, yeah. It's unmarked? Yes. There are stones at each side, is that correct? Yes. Beyond the stones, there are houses on each side, most of them with grass. Is that right? Yes, yes. After running for about 30 metres, what happened? So we crossed the road. I followed him. We crossed the road and he sort of got to a tree and he slipped over. It felt like to me he went to turn around the tree and he slipped over. And that was the point that I was able to really gain on him and catch up to him at that point. Officer MTS1 gave this evidence. Just describe what happened there. As I said, it appeared to me there was a tree out the front of the house there, one of those, the council strip. It appeared to me he might have been trying to loop around that, and as he's done that, his feet slipped out from underneath him. Officer MTS1 described the tripping as follows. When you said he tripped over, can you describe what actually happened to him? As I say, just like his feet sort of slipped out from under him, as he turned, he slipped over. He didn't trip on anything. I didn't see him trip on anything. It was just more of a slip. Later, Officer MTS1 stated, "What did he do after getting up?" And then I had closed at that point, and as he got up, he went to run again, and I managed to grab hold of his jacket or jumper, and I don't know whether it was just him running or him twisting, but it pulled through my hands. It was one of those waterproof sort of jumpers, and that pulled out through my hand, and he kept running back, sort of looping around the tree. Officer MTS1 said, "Was there a point in time when you had another piece of contact with him?" "Yes. As he sort of got around the tree, I managed to get close enough and tackled him." When you say tackled, what do you mean? I just shoulder into sort of his upper region and tackled him to the ground, like a rugby league tackle. Did you actually put both of your arms around his body in that tackle, or was it like a shoulder charge? No, it would have. It wasn't. Certainly wasn't a shoulder charge. It was both arms around him. Why did you do that? To apprehend him, to bring him, to stop him from running away and apprehend him. What happened when you tackled him? We fell to the ground. He was under me and I was on top. Just in that position over the top, I managed to get his left arm out, I think it was, and I had hold of that behind his back. And I said to him, "Mate, it's the police. Don't be silly. It's the police." And then originally he had his other hand tucked under his body. He wouldn't pull it out. I managed to get it out. I don't know if he just released it or I managed to get it out. I got it out and then cuffed him. He was on his stomach and I cuffed him. YPM1. YPM1 was in the town on the night with other young people. He described being chased by a group of men who turned out to be the police. He said that after he and his friends had dispersed, following their first contact with this group of men who were in plain clothes, the following happened. "Where did you run to?" "Behind a tree." "Behind a tree?" "Yeah." "Was anything being said? Was anyone saying anything as these two fellows were chasing you?" "Yes, he just said, 'You're under arrest.'" How long were you being chased for before someone said, "You're under arrest"? "About 30 seconds. When someone said, "You're under arrest," where were you at the time? Still on name of the street. Still on name of the street. And you mentioned that you went behind a tree. Were you behind the tree when someone said you were under arrest, or were you somewhere else? No, when he got me down, he said, "You're under arrest." What happened before this person got you down? So you were being chased and you were running away, is that right? Yeah. Where did you see your friends and the other people? Where did you see them go? We all split up. What happened when you got towards this tree? You talked about being behind a tree. Did something happen behind the tree? No, he just tackled me, started punching me, and that. Before you got tackled, did you ever fall to the ground? Or was the first time you, went to the ground when you got tackled? What? So when you got tackled by this person, did you fall to the ground? Fall to the ground? Did you fall on the ground when he tackled you? Yeah. Before he tackled you, did you fall on the ground at all? Nah. When this person tackled you, how did that happen? What did he do? He just dived and hit me in the leg and then tripped. Were you facing towards him when he dived, or were you facing, no, in the other direction, facing the other direction? And before you tripped, what was it that you were doing? Nothing. Were you running away at that time? Nah, I couldn't. Why is that? Because he had me on the ground. Before he had you on the ground, after diving at your leg and tripping you over, did you ever fall on the ground before that time? Or was that the first time you fell on the ground? That's the first time. When you say he dived at your leg, did you see what it was that he did? No. What happened when you fell on the ground? Hit my head. Where did you hit your head? You hit your head. What did you hit your head on? Gravel. After you hit your head, what was the next thing that happened? Started punching me. When you say he started punching you, how many times did he punch you? 4. 4 times? Yes. Which parts of your body did he punch you? Just around my body. You just showed with your hand, you just motioned towards your chest. Is it the left side of your chest? Yeah. Did he punch you anywhere else? Nah, he picked me up and slammed me to the ground. Was that before he punched you or after he punched you? After. When he was punching you, did he say anything? No, he just said, "You're under arrest." Was that before he was punching you, after he was punching you, or while he was punching you? After. So while he was punching you, did he say anything to you? No. Did you say anything to him? No. While he was punching you, did you know who he was? No. After he punched you those 4 times, what happened next? He walked me up the street and one of the other officers punched me in the belly once. Now, you mentioned that the other person who punched you 4 times picked you up and slammed you. Is that right? Yes. How did that happen? He picked me up from the back, and then chucked me on the ground. When you say he picked you up from the back, which part of your body did he touch, or your clothes? Just at the back here, indicating. So you've just touched the back of your jumper. Did you have a hold of something when he picked you up? No. How did he pick you up? What was it that he did? He just grabbed me. How many hands did he grab you with? 2. Were you facing towards him at the time, just before he picked you up, or were you facing in another direction? Facing the other direction. How do you know that he picked you up with 2 hands? Because I could feel it. How far up did he pick you up off the ground? Were you able to tell? How far up off the ground were you picked up? Were you able to tell? Nah. When you say you were slammed on the ground, what was it that happened? He just slammed me onto ground. How hard did you hit the ground? Hard. Which part of your body hit the ground? My head. Which part of your head are you able to say hit the ground? About here, over here, indicating. You're just showing on the right-hand side of your head, just up at the top of your head. Is that right? Yeah. Did it hurt you when you hit the ground and hit the side of your head? Yeah. And did anything happen to that side of your head after you hit the ground? It was bleeding. Did you notice that side of your head was bleeding at any time before you hit the ground? No. After your head hit the ground, what was the next thing that happened? He walked me up to the side of the road and one officer punched me in the belly once, and then my auntie pulled up. You mentioned that the person said, "You're under arrest" at some time. How long after you were slammed to the ground did that person say that you were under arrest? Huh? Do you remember saying that that person who slammed you to the ground said to you, "You're under arrest"? Yeah. You talked about being punched and then slammed to the ground. How long after you were slammed to the ground did that person tell you that you were under arrest? Can't remember. Was that person, after you were slammed to the ground, was he holding you down on the ground in any way? Yeah. How was he doing that? He just had one leg on my legs and one hand on my back. Where was your face at the time he had his leg on your leg and a hand on your back? On the grass. What happened when you saw this other person? He just punched me in the belly. Punched you in the belly? Yes. How hard was that punch? Hard. Did you say anything? No. Did the other person say anything, the one who punched you in the belly? He said, "You're under arrest," too. MTS2 said he did not see the contact between YPM1 and Officer MTS1. He saw YPM1 only after he had been arrested by Officer MTS1. Later, he saw YPM1 handcuffed and he could see that YPM had blood, quote, "sort of on the side of his face here," end quote. He said, quote, "YPM1 was crying. He was yelling out saying, 'Help me, I haven't done anything, I can't breathe.'" Describing a point later in time when YPM1 started to look unwell, Officer MTS2 gave this evidence. At that point of time when YPM1 was falling, started to look lethargic as you've described, did he still have his handcuffs on? Yes, he did. Were his hands behind his back or in front of his back? I think they might have still been behind. What did you do about that? The fact that arranged to move them, to get someone to move them to the front. Why was it necessary that the handcuffs, that he remained handcuffed given the state he was in, YPM1, M1, once he became lethargic? Yes. There probably was less of a need for him to remain handcuffed, but being handcuffed to the front, it still was, he was in a position where he wasn't needing to, it didn't change his position. What was he going to do if he was not handcuffed? I don't think he would have done a great deal. Were you the person who gave the direction that the handcuffs were to be moved so that his hands were going to be handcuffed in front of him rather than behind him? Yes, I did. Why did he have to remain handcuffed? I think the handcuffs probably could have been removed at that time. The whole time that he was lethargic, he had handcuffs on. They were taken off once the other medical help arrived. That's the ambulance that arrived later on, is that correct? The fire truck, I think. How long between you seeing YPM1 being lethargic and having the handcuffs moved to the front of his body until the fire truck arrived? I can't remember, sorry. An ambulance was called and YPM1 was taken to hospital. The Commission has the VKG, that is the New South Wales Police Force radio call sign, recordings for the night, which relevantly start at 9:30 p.m. and continue till almost midnight. The relevant calls include the following: 21:30, just got one in custody, ... just after a caged truck, please. 22:17, caged truck, ... to assist, ... got one in custody, ... 22:19, for caged truck that can assist, ... please. One is custody, ... requesting a caged truck to their location, please. 22:28, can we get an ambulance to start making its way to the location? Got a 14-year-old male, conscious breathing, ... got a bit of a head laceration, ... difficulty breathing. Yeah, ... Can we get undescribable? That ambulance if we can, ... in and out of consciousness. VKG, copy that, will do. 2232, just chasing update on Ambo when you can. Yeah, just for the Ambos, mate. He's had a tumble, got a head knock, bleeding reasonable heavy from the head. He's just in and out of consciousness at the moment. VKG, copy that. VKG, our side is just on the phone to the Ambos now, just seeing if we can get a quick response. 2236, Ambos are responding, lights and sirens, ... They've also tagged the fire brigades to see if they can assist with medical assistance due to the response time. 2309, VKG, Ambos should only be a couple of minutes off. 2329, did Ambos make it to your location? That was a question asked by VKG. The response is, they've been, thanks. YPM1 was taken to hospital. He was treated for ongoing pain to his temples or the sides of his skull and had multiple grazes on his face. The discharge summary noted a, quote, head injury with concerning mechanism of injury, end quote. The injuries noted were small subgaleal, SUBGALEAL, hematoma, that is, bleeding between the skull and the skin on the scalp. The head wound was cleaned. The discharge summary notes that there were no lacerations or cuts seen at the time of discharge. YPM1 was then taken to a police station. Return to police station and interviewing. When YPM1 arrived at the police station soon after 6 a.m, the custody manager was Officer MTS8. A custody manager is a police officer who has specific responsibilities for people in custody, including ensuring the person's rights are protected. Officer MTS8 had responsibility for YPM1. Officer MTS8 tried to arrange for a support person to go to the police station to stay with YPM1 while he was in custody. Officer MTS8 tried unsuccessfully over a number of hours to arrange this. During YPM1's time in custody, Officer MTS8 arranged for YPM1 to have a telephone call with the Aboriginal Legal Service to advise him of his legal rights and give him legal advice about being interviewed by police. The Aboriginal Legal Service runs a telephone legal advice service which operates 24 hours a day, 7 days a week. It enables Aboriginal people in custody to speak to a solicitor. YPM1 spoke to the solicitor on call at the time, Mr. Jonathan Whitting, WHITTING, who recorded the following. He gave YPM1 advice about the right to silence. He told YPM1 that he did not have to and should not go into an interview room. He told YPM1 not to discuss the allegation with a support person. He gave YPM1 advice not to do a recorded interview. He gave YPM1 advice not to give a written or notebook statement to police. YPM1 told Mr. Whitting he wished to exercise the right to silence and his solicitor could disclose his instructions to the police. Mr. Whitting confirmed YPM1's instructions that there would be no electronically recorded interview or statement. YPM1 was not to be taken into an interview room. YPM1's instructions were to be recorded in the custody management records. Mr. Whitting would send an email to police. Mr. Whitting stated in his private examination, When you've asked custody managers to ask to have your client's instructions being recorded in the custody management records, what sort of responses have you got? Mostly the police are agreeable to doing that. Occasionally, we do get some pushback. Some of the responses I've had are, the custody management record is not for that purpose. It's, quote, your advice to your client is between you and him, end quote. That is a comment. I've had occasionally I've had police say, quote, well, we still want to put the allegations to the person out of fairness, end quote. Or police sometimes have expressed a sense of obligation that they themselves wanted to hear from the person themselves personally, that that's the person's instructions. Officer MTS8 gave this evidence. What did you say when Mr. Whitting asked you to make a record in the custody management records? I didn't say that I would or wouldn't. It was just, quote, I would just like it recorded in the custody management record. Did you ever record that in the custody management record? No. Why is that? That's his private legal advice. I don't believe it's something for the record. But his private legal advice was relevant to whether he wished to be interviewed by police. Do you understand that? Yes. It's important, isn't it, to make a note in the custody management records that here, YPM1 did not wish to be interviewed by police. Do you agree with that? It's not something that I've ever done, no. You've never done that at any time while you've been a custody manager? You've never made a note of whether the person wishes to be interviewed or not interviewed? Is that what you're saying? Yes, that's what I'm saying. I don't ever record their legal advice in the custody management record. A little while later, are you aware that the custody management records that you are responsible for are relevant both to the care of the person there at the time with you, as well as later, as a record of what took place when that person was under your responsibility? Are you aware of that? Yes. Doesn't that mean then that you need to put as much information as you possibly can so that other people, other police, can have access to that information, and other people if necessary? Do you agree with that? Yes. Later, a support person, referred to as STM4, came to the police station and stayed with YPM1 while he was in custody. During the morning, two investigating police officers, MTS9 and MTS10, spoke to MTS8, the custody manager, YPM1 and STM4, the support person. They arranged for YPM1 to be interviewed in an interview room on camera with STM4 present. The evidence is unclear about what MTS8 told MTS9 and MTS10 about whether YPM1 wanted to be interviewed and whether MTS9 and MTS10 even asked about this. In a statement made to the Commission, the support person, STM4, said he went to the police station to act as a support person for YPM1 while he was in custody. STM4 was not told by the custody manager or by investigating police YPM1 had been given legal advice. STM4 was present when investigating police spoke to YPM1 about being interviewed. YPM1 agreed to being interviewed. Early in the interview, YPM1 was asked the following questions and gave the following answers. So do you agree to be interviewed on this machine by video? No. You don't want to be interviewed? What? Do you agree? Are you happy to be interviewed on this machine? Yeah. The interview then went ahead. There was no further clarification of whether YPM1 wanted to be interviewed. The interview was not paused to enable YPM1 to get further legal advice. During the interview, YPM1 confirmed what happened when he was apprehended by MTS1. He said this to the police. And one of them chased the other guys, and one of them chased me. Then he bashed me, then, yeah. And what happened after that? That's all. And when they were chasing you, what did you do? Stopped? And I slipped. You slipped? Yeah. Yep. What happened when you slipped? He started bashing me. Yep. So you slipped? Did you fall over? Yeah. Yep. Did you hurt yourself when you fell over? Nup. No. And then so they started bashing you. Yeah. What happened there? YPM1 did not explain what happened when he was bashed. Neither MTS9 nor MTS10 asked him again to explain what happened. Neither officer made any report after the interview about YPM1 saying he had been bashed by police. Mr. Burkett, Mr. Clifford, Ms. Burkett, Mr. Clifford, Mr. Frankham. 3 witnesses gave evidence at the private examinations about systemic issues regarding young people being interviewed by police even when they refused to take part in an interview and police had been advised of this refusal. They were Ms. Alex Burkett and Mr. James Clifford, solicitors from the Aboriginal Legal Service, and Mr. Ron Frankham from the Children's Legal Service at Legal Aid New South Wales. Ms. Burkett was previously the manager of the CNS, Custody Notification Service, within the Aboriginal Legal Service between August 2019 and March 2020. She had taken approximately 2,900 telephone calls from Aboriginal people in custody. Mr. Clifford is Managing Solicitor for New South Wales and the ACT of the Children's Criminal Law Practice at the Aboriginal Legal Service. Mr. Frankham is the Manager of the Children's Legal Service within Legal Aid New South Wales. The Children's Legal Service provides legal advice and representation to children, as well as a legal hotline for young people in custody, called the Legal Aid Youth Hotline. Mr. Frankham gave evidence about a protocol between the Commissioner of Police and Legal Aid New South Wales regarding children getting legal advice in custody. The protocol includes this section. If the young person exercises their right to silence, the investigating officer should record this in COPS event as, quote, interview declined, end quote. The custody manager should also record in the general comments of the custody management record that the young person declined an interview. Mr. Frankham's experience was this protocol was inconsistently applied. There were many instances when it did happen, but also many when it did not. Mr. Frankham described examples of conversations with custody managers as follows. It can involve a conversation either with the custody manager or the officer in charge of the investigation. There are often, back and forth conversations where generally our solicitor will say, quote, the young person wishes to exercise their right to silence. They don't wish to participate in an interview. They don't wish to have their refusal to participate in an interview recorded either on ERIS or other tape, end quote. And that's where we sometimes fall into disagreement, where you'll get either a custody manager or an officer investigating the alleged offences saying they either want to record the refusal or they want to interview the young person. Often we get comments like, quote, in fairness to put the allegation to them, end quote, and comments like that. And we have an example as recently as last night. Ms. Burkett gave this evidence. I have personally experienced some issues with this, with making these requests of custody managers or officers in charge of a matter through my work on the CNS. You are often met with resistance where some officers can be uncooperative. When asking for these instructions to be recorded in the custody management records, comments are sometimes made like, quote, it's my custody management record, you can't tell me what to add to it, end quote, or, quote, no, I won't be doing that, end quote, when we ask for it to be recorded. We also have within our CNS form information that if those instructions are given, that we should pass on to the custody manager to call the ALS back if the instructions change. And so that mostly, in my experience, never happens. And it is only when you get to the court process that you realise that the instructions have subverted or the interview has taken place. Ms. Burkett explained, it's at that point where there are some officers, be it the custody manager or an officer in charge, who will essentially disagree with that piece of information and say, quote, well, I'm going to be offering them the opportunity to be interviewed out of fairness, end quote, or, quote, it's my own practice that I offer them the opportunity to be interviewed. I'm just going to take them into the interview room or film them for the purpose of refusal, put them on camera, or ask them to sign a notebook statement as well, end quote. And that's when you do get into a conversation with officers or an argument about the fact that you have been provided advice by the young person that they specifically do not wish to do that. This is something, they say, the opportunity for them to hear the allegations is another reason that I've heard. And these comments are so frequent in my own practice, or it is general practice at the ALS, to teach junior solicitors how to deal with those comments on the CNS during their initiation, during that process. Ms. Burkett also stated, in my experience on the CNS, I've had officers suggest that young people may get bail if they do an interview, and this is often said directly to me in a way where the young person in the station can hear it, or where I've heard it being said to the young person through the phone. Quote, we can't consider bail unless you do the interview. We don't know what happened. We want to hear your side of the story, end quote. And it's sort of used as a carrot for these young people where they think that they are getting out of custody, where they think they are not getting out of custody unless they comply with these requests. The situation was so bad in one location in New South Wales that Mr. Clifford wrote to its superintendent. The superintendent's reply included the following. There have been circumstances when young people are ultimately interviewed and based on our advice / practice, police have conducted interviews appropriately. Ultimately, the court determines fairness of admissions at that time in a relevant forum. Mr. Frankham said, I've been told personally things to the effect of, in fairness to the young person, I just want to put the allegation to them. I've been told things such as, quote, it's my standard practice to have the recording of a person's refusal to do an interview, whether that be in an heiress room or on body-worn camera, end quote. And in addition to personally, I've also been told by many staff that they have experienced similar situations. Mr. Frankham gave evidence about a police circular issued by New South Wales Police in 2005. Part of that circular states that police do not have the power to compel a suspect to participate in an interview. Each of these three solicitors who gave evidence ran hearings where an heiress was conducted despite a young person having expressed the desire to exercise their right to silence, and that desire having been conveyed in writing to a custody manager or officer in charge. A further systemic issue, the role of the custody manager. As a result of the evidence given at the private examinations, a further systemic issue has been identified, which is the following relating to New South Wales Police custody managers: their training, their role, which is to protect people in custody, and particularly vulnerable people, their understanding of their role, recording their interactions with people in custody, particularly vulnerable people, recording and conveying of the instructions of people in custody to investigating police. Another issue which has come about in this investigation is the degree of force used in YPM1's arrest. The evidence in the coming week. The evidence in the coming week will focus primarily on systemic issues which have been identified. Legal Aid New South Wales and the Aboriginal Legal Service have made submissions in writing about the issue of young people in custody being interviewed even after legal advice has been given, and they do not agree to being interviewed. Both organisations have highlighted that the majority of police and custody managers carry out their investigative role and custody management functions properly. However, the issue of young people in custody being interviewed even after legal advice has been given and they do not agree to being interviewed is one that frequently comes up. This frequency and consequent systemic nature of the problem is evident in a number of cases which have been before the Children's Court, District Court and Supreme Court, where admissions obtained by police from young people have been excluded. These cases continue to come before the courts. Concern about this issue has also been raised with the Law Enforcement Conduct Commission by the New South Wales Director of Public Prosecutions, Sally Dowling SC, in February 2023. At least 2 Assistant Commissioners of Police are expected to give evidence this week. They are Assistant Commissioner Cotter, giving evidence particularly about custody management, and Assistant Commissioner Crandell, relating to the use of body-worn video. They will be asked questions on a number of topics, including custody management, standard operating procedures relating to custody management, the role of the custody manager, how the role is regulated, what happens when a person arrives at the station in police custody, communications between the custody manager and investigating police, what communications and recording are undertaken if investigating police want to interview a person in custody, direct contact between investigating police and the vulnerable person before, during, and after legal advice has been given, understanding of the obligations to contact a solicitor if a person in custody changes their decision regarding being interviewed, support persons, keeping of custody management records, how records are created and kept, what is to be recorded in custody management records, allegations against police regarding use of force and other specific entries which should be made in custody management records, what is to be recorded about legal advice received and sought by people in custody, recording of discussions with the person's solicitor, interviewing vulnerable persons in custody, refusals to be interviewed, why these are recorded and why they are necessary, and the use of body-worn video. There will also be an examination of reasonable force used in arrest. The following will also give evidence at the public examinations. Ms. Keisha Hopgood, the Acting Principal Legal Officer of the Aboriginal Legal Service, and Mr. Ron Frankham, the Head of Legal Aid New South Wales Children's Legal Service. They will give evidence of their experience and the experience of their legal services with police, particularly regarding speaking to police when young people are in custody and whether children should be interviewed or not. Finally, Chief Commissioner, at the outset of the hearings on the 14th of December 2022, the Commission heard submissions orally and later received submissions in writing about whether evidence should be taken in public or private. A public judgment was issued by the Commission. There was a private judgment which was also issued, which was then limited to the parties. That private judgment, with some redactions and some explanation of events subsequent to its handing down, will be made public and will shortly appear on the Law Enforcement Conduct Commission's website. Chief Commissioner, I will shortly turn to tendering exhibits at the public examination and then calling Mr. Frankham Could I have a short adjournment before doing so?
Yes, just before we do adjourn, as council assisting has recently observed, the Commission issued a public decision on the 3rd of March 2023 concerning the use of public and private examinations in aid of the investigation in Operation Mantus. That public decision has been on the Commission website since that day. In addition, as council assisting has observed, and as the parties granted leave are aware, the Commission issued a confidential decision. That confidential decision provided a further explanation of the reasons why a combination of private and public examinations were to be used. As stated in that confidential decision, the Commission considered whether the confidential decision could be released with certain redactions. A decision has been made that will take place. I have given a direction that the confidential decision in its amended form will be placed on the Commission website today and will be available to the public. There are limited continuing redactions from the confidential decision. The things redacted are, in essence, the precise location in northern New South Wales where events occurred, and one other paragraph relating to other proceedings. There are also contained in the confidential decision, in its amended form, footnotes explaining certain events which have occurred since the confidential decision was first released on a limited basis to those who'd been granted leave to appear. So that confidential decision will now be made public on the Commission website. How long would you ask for at this stage?
We have Mr. Frankham coming at 11:30. He
All
just
right.
has to juggle some other things. So 11:35, if that was possible, please,
All
Chair
right.
Commissioner.
Yes. Well, the Commission will adjourn for the moment until 11:35 a.m. Yes, Mr. Fernandez.
Two matters before I call Mr. Frankham. Chief Commissioner, can I correct my opening from this morning? When I turned to the background early in my address, I referred to two officers who were both senior officers in the relevant police district. I referred to them mistakenly as MTS 9 and MTS 10. They were in fact MTS 6 and MTS 7.
Yes.
Mr. Frankham, I will shortly call to give evidence. I understand Ms. Lua is here and will be seeking leave.
Yes.
Yes, Chief Commissioner. Lua, L-E-W-E-R. I seek leave to appear for Legal Aid New South Wales.
Yes. Thank you. That leave is granted. Thank you, Ms. Lua.
Chief Commissioner, could I
Yes,
just
Mr. White.
correct one thing that was also said by my learned friend? It was indicated that MTS 4, who I represent, also gave evidence in the private hearing, but he did not. And he was, in fact, summoned, but was not required by the Commission.
Is that...
MTS 4 was the support person.
yes.
When I referred to
No.
him,
Yes, indeed.
oh, sorry, STM 4 was the support person, and when I referred to his evidence, I referred to what I was referring to as the recorded interview that he has given, which is an exhibit in the private examination. But he wasn't called to be.
Officer MTS 4, did Officer MTS 4 get called at a private examination in February or March?
I might just confirm the pseudonyms, which I'll confirm.
There is an element of complication in the shooting them, but MTS is obviously
Yes.
based on a short form of Mantus. STM, I think, is to distinguish civilians versus police officers.
I now
But there's a
confirm,
risk of
yes.
slips.
Yes, I do now confirm that Officer MTS4, Mr White's client, did not give evidence at the private examinations.
Yes, all right. Yes, thank you, Mr White, for clearing that up. All right, yes, Mr Fernandez.
Chief Commissioner, I tender the following exhibits in the public examination. I think we're up to MTS 62 is the is the first exhibit. I tender a redacted email from Jonathan Whitting to MTS 1 and MTS 8. That's the arresting officer and the custody manager on the 12th of September 2022. The barcode for that document is 862-0258.
The redacted email from Jonathan Whitting to MTS1 and MTS8 on 12 September 2022 will be marked Exhibit MTS 62.
I tender a redacted call form record from the Aboriginal Legal Service. It's a custody notification system document concerning YPM1, and it's dated the 12th of September 2022. The barcodes are 8543557 through to 559.
The redacted call form record custody notification system by the Aboriginal Legal Service concerning YPM1 dated 12 September 2022 will be marked Exhibit MTS 63.
I tender a redacted document which carries the title Role of a Support Person, signed by STM4, that's a support person, on the 12th of September 2022. The barcode for that document is 8543560.
A redacted document titled Role of a Support Person, signed by STM4 on 12 September 2022 will be marked Exhibit MTS 64.
I tendered the submission made by Legal Aid New South Wales to the Commission dated March of 2023. The barcodes are 8543561 through to 8543584.
The submission of Legal Aid New South Wales to the Commission entitled Systemic Issues and Practices in Police Interviews with Children and Young People will be marked Exhibit MTS 65.
I tendered the submission of the Aboriginal Legal Service to the Commission, also dated March of 2023. The barcodes are 8543585 through to 8543605.
The submission of the Aboriginal Legal Service to the Commission entitled Systemic Issues Relating to Police Practices of Interviewing Children Following Refusal of Interview, dated 30 March 2023, will be marked Exhibit MTS 66.
I tender a redacted email between Legal Aid New South Wales and the New South Wales Police Force regarding use of body-worn video in questioning young people. The barcodes are 8543606 through to 8543608.
A redacted email between Legal Aid New South Wales and the New South Wales Police Force regarding use of body-worn video in questioning young people will be marked Exhibit MTS 67.
I tender redacted emails between the Aboriginal Legal Service and New South Wales Police dated the 19th and 22nd of August 2022. These emails relate to interviewing young people after they've refused, accepted the right to silence advice. The barcodes for these emails are 8543609 to 8543610.
Redacted emails between the Aboriginal Legal Service and Police dated 22 August 2022 relating to the interviewing of young people after receipt of legal advice will be marked Exhibit MTS 68.
Now tender a number of cases which are on point in relation to this investigation about interviewing of children following legal advice. Tender a judgment of Judge Nicholson in the District Court in 2006 of the Queen and capitals A, P, C, R and the Queen and capital C, P.
The decision of His Honour Judge Nicholson SC in R versus APCR, R versus CP, square bracket 2006 NSWDC 12 will be marked Exhibit MTS 69.
I tender the case of Crown and F, capital F, Foxtrot, E, a judgment of Justice Adamson in the Supreme Court in 2013. The barcode is 8543630 to 8543658.
Decision of Justice Adamson in R versus FE, square bracket 2013 NSWSC 1692 will be marked Exhibit MTS 70.
I tender a judgment of Justice Hamill in the Supreme Court in the Queen and Taleb, T-A-L-E-B. The citation is square brackets 2019, end square brackets NSWSC 241. The barcode for this judgment is 8543659 through to 8543716.
The decision of Justice Hamill in R versus Taleb, square bracket 2019 NSWSC 241 will be marked Exhibit MTS 71.
I tender a judgment of Judge Grant in the District Court of the Queen and DN, capital D, capital N, square brackets 2019, N square brackets NSWDC 492. The barcodes are 8547005 to 8547015.
The decision of His Honour Judge Grant in R versus DN, square bracket 2019 NSWDC 492 will be marked Exhibit MTS 72.
I tender a judgment of Judge Yehia, as Her Honour then was, in the Queen and DB and the Queen and AP, square brackets 2020, end square brackets NSWDC 472. The barcodes are 8547016 to 8547048.
The decision of Judge Yehia SC, as Her Honour then was, in R versus DB, R versus AP, square bracket 2020 NSWDC 472, will be marked Exhibit MTS 73.
I tender a judgment of Justice Hamill in the Supreme Court in the Queen and Archer, number 1, square brackets 2021, end square brackets NSWSC 569. The barcode is 8547049 to 8547076.
The decision of Justice Hamill in R versus Archer, bracket number 1, square bracket 2021 NSWSC 569 will be marked Exhibit MTS 74.
I tender the judgment which will be referred to in this commission as the police against ABC. It's a judgment of Magistrate Hamilton in the Children's Court on the 6th of July 2021. The barcode for this judgment is 8547077 to 8547114.
I'll just pause for a moment. The document, I think, is the transcript of that day, which includes the transcript of evidence and the judgment of Magistrate Hamill.
That's so, Chief Commissioner.
And having regard to the fact that that is a Children's Court decision and which has not been published on case law, steps have been taken to edit it in various respects.
Yes, that's so.
Having regard to the jurisdiction involved. The transcript and judgment of a hearing in the Children's Court described as R versus ABC, including the judgment of Magistrate Hamilton on 6 July 2021, will be marked Exhibit MTS 75.
I tender the judgment of Judge Herbert in the District Court in the matter of Queen and Lindsay. The date of the judgment is the 1st of April 2022. The barcodes are 8547115 to 8547155.
The judgment of Her Honour Judge Herbert in R versus Shane Lindsay, Parramatta District Court on 1 April 2022 will be marked Exhibit MTS 76.
I tender the transcript of proceedings in the Children's Court. They'll be referred to as the police and DEF. Having regard to the jurisdiction, a number of details have been redacted and anonymised. This is a transcript of proceedings before Children's Court Magistrate Wilson on the 18th of May 2022. The barcodes are 8544463 to 8544470.
The transcript and decision of Magistrate Wilson in the Children's Court in Police versus DEF on 18 May 2022 will be marked Exhibit MTS 77.
I tender the judgment of Judge Buscombe, Buscombe, in the District Court in the case of the King and Nean, NEAN, square brackets 2023, end square brackets, NSWDC 34. The barcodes are 8544471 to 8544524.
The decision of His Honour Judge Buscombe, dated 30 January 2023, in R versus Nean, square bracket 2023, NSWDC 34, will be marked Exhibit MTS 78.
I'll just pause to advise you, Chief Commissioner, that there's a judgment that's been provided by Judge Johnston, who at that time was the President of the Children's Court.
Judge John Stone,
John Stone,
J-O-H-N-S-T-O-N-E,
I'll
just for
tender
clarity.
that. Yes, I'll tender that separately
Yes.
and at a later point in time. I tender...
There was also an unrevised judgment of Justice Fullerton, which was provided to the Commission. And I should just indicate this, that Justice Fullerton presided at a judge-alone trial last year with respect to a number of persons, including a Mr Weatherall, Weatherall, and others. There was an objection to certain interviews. Her Honour excluded a number of those interviews. There was what is an unrevised judgment of Justice Fullerton, which was provided to the Commission. That judgment was unrevised because Her Honour proceeded to hear and determine the trial of each of the accused as a judge-alone trial, and each of the accused was acquitted. There was no application for leave to appeal from Her Honour's interlocutory judgment on the objections to interviews, nor was there, of course, any appeal against the ultimate acquittals. Her Honour has now retired from the Supreme Court. The Chief Judge at Common Law was good enough to provide to the Commission the unrevised judgment of Justice Fullerton. There is no criticism expressed of the fact that that judgment is unrevised. It is entirely understandable because there was no purpose in it being revised. And there is no criticism of the court, of course, in circumstances where that decision was provided to the Commission in that informal state. The Commission is grateful for the court for that assistance. As I understand it, that judgment does not involve young persons, but in fact persons who are adults. For the moment, it's not being tendered. If it is tendered at some point, it will be subject to all the qualifications which I've just expressed. But it did involve, on my understanding of it at least, with respect to one or perhaps more of the accused, a scenario where the Aboriginal Legal Service indicated the accused did not wish to be interviewed by police, but the police proceeded to interview nevertheless.
Yes.
So I mention that at this point. It's in a different category to the other judgments which involve young persons, and it's appropriate that the Commission note that it's been provided by the court and to express its gratitude for receiving the judgment in the circumstances I've outlined. Yes, Mr Fernandez.
I tender an extract from the New South Wales Police Force Handbook concerning questioning of suspects. The barcode is 8544525.
The extract from the New South Wales Police Force Handbook concerning questioning suspects will be marked Exhibit MTS 79.
I tendered the standard operating procedures of the New South Wales Police Force concerning charging and custody management in force on the 12th of September 2022. The barcodes are 8544526 to 8544565.
The New South Wales Police Force standard operating procedures concerning charge room and custody management as in force on 12 September 2022 will be marked Exhibit MTS 80.
I tendered the New South Wales Police Force standard operating procedures concerning body-worn video in force as of November 2022. The barcodes are 8620182 to 8620198.
The New South Wales Police Force standard operating procedures concerning body-worn video as in force as at November 2022 will be marked Exhibit MTS 81.
I tendered the New South Wales Police Force Handbook on the use of force. The extract is 8620199.
An extract from the New South Wales Police Force Handbook entitled Use of Force will be marked Exhibit MTS 82.
I tender a document called the Use of Force Principles by the Australian and New Zealand Policing Advisory Agency, ANZPAA. The barcode for this document is 8620200.
The Australia-New Zealand Use of Force Principles issued by the Australia-New Zealand Policing Advisory Agency will be marked Exhibit MTS 83.
I tendered the New Zealand Police Use of Force Overview dated the 5th of August 2022. The barcodes for this document are 8620201 to 8620249.
The Use of Force Overview dated 5 August 2022, issued by the New Zealand Police, will be marked Exhibit MTS 84.
I tender a one-page redacted police statement of facts relating to admissions by a young person. The barcode is 8620250.
A redacted page of a statement of facts concerning admissions with respect to a young person will be marked Exhibit MTS 85.
I tender a redacted page taken from a police statement of facts relating to a young person, which refers to recordings made of admissions on body-worn video. The barcode is 8620251.
A redacted page from a statement of police facts concerning the use of body-worn video will be marked Exhibit MTS 86.
I tender an article from the Daily Telegraph of the 30th of March this year titled Police Review Rules for Body-Worn Cameras for Specialist Officers. This relates to an incident which took place in Queensland. The barcodes for this document are 8620252 to 8620256.
An electronic article in the Daily Telegraph on 30 March 2023 entitled Police Review Rules for Body-Worn Cameras for Specialist Officers will be marked Exhibit 87, MTS 87.
I tendered the Legal Aid Youth Hotline precedent letter sent to police. This is a document in the form of a template. The barcode is 8620257.
The Legal Aid New South Wales precedent letter as sent to police will be marked Exhibit MTS 88.
I tender the Legal Aid Youth Hotline telephone advice report. This is a form of an electronic template. The barcodes are 8620259 to 8620260.
The Legal Aid New South Wales electronic template with respect to telephone advice will be marked Exhibit MTS 89.
I tender New South Wales Police Force Circular number 2 of 2005. This relates to interviewing of suspects. The barcode is 8620261.
The New South Wales Police Force Circular number 2, issued in 2005, with respect to interviewing suspects, will be marked Exhibit MTS 90.
I tender some redacted pages from a statement of police facts relating to a young person. The barcodes for this document are 8620362 to 8620363.
Redacted pages from a statement of police facts concerning a young person will be marked Exhibit MTS 91.
I tender redacted pages from a statement of police facts relating to a young person. The barcodes for this document are 8620364 to 8620365.
Redacted pages from a statement of police facts concerning a young person will be marked Exhibit MTS 92.
Chief Commissioner, I now call Mr. Ronald Frankham from Legal Aid New South Wales.
Just before that occurs, the article of in the Daily Telegraph of MTS 87, I think you noted in passing, concerned an incident in Queensland last week.
Yes, that's right.
It's not a New South Wales incident,
It's not.
but it's one where plainclothes police forming a specialised unit were not wearing body-worn video at a time that a person was shot dead.
That's correct, Chief Commissioner.
And there is controversy in Queensland about that.
Yes.
Yes.
Do you solemnly and sincerely declare and affirm that the evidence that you should give will be the evidence, will be the truth, the whole truth, and nothing but the truth? If so, please say I do.
I do.
Thank you. Have a seat, if you would, Mr. Frankham. Yes.
Can you please state your name?
Ronald Frankham.
Are you the manager of Legal Aid New South Wales Children's Legal Service?
That's correct.
Mr. Frankham, did you give evidence at a private examination before this commission on the 17th of March this year?
I did.
Mr. Frankham, you're aware that Legal Aid New South Wales has prepared a submission to this commission. It's now an exhibit. You might have heard me go through a number of exhibits. It's Exhibit MTS 65, and it's titled Systemic Issues and Practices in Police Interviews with Children and Young People. Do you have a copy of that document before you?
I do.
Is that a submission that you were heavily involved in the preparation of?
I had input.
It contains a number of case studies and the experiences of Legal Aid New South Wales as an organisation with police relating to a number of different matters which are being investigated by this investigation. Is that correct?
That's correct.
How long have you been admitted as a solicitor?
Since 2007.
How long have you worked at the Children's Legal Service?
I've been at Legal Aid since 2011. In that time, I've had 2 stints in the Children's Legal Service, so roughly around 7 to 8 years all up of my time at Legal Aid has been at the Children's Legal Service.
And when were you appointed the manager of the Children's Legal Service?
At the end of 2018.
During those periods of time when you've been at the Children's Legal Service, have you been involved in something called the Legal Aid Youth Hotline?
Yes.
Is that a free service provided by Legal Aid New South Wales, which is staffed by solicitors at Legal Aid New South Wales?
Yes.
Those solicitors all have expertise in children's criminal law, is that correct?
That's correct.
The Youth Hotline provides legal advice and information to young people under 18, and it operates from 9 a.m. to midnight on weekdays and 24 hours between Friday at 9 a.m. to Sunday midnight, as well as on public holidays. Is that correct?
That's right.
The Legal Aid Youth Hotline is frequently contacted by police on behalf of children who are in custody at police stations. Is that correct?
Yes.
The Aboriginal Legal Service also conducts a service called the CNS, Custody Notification Service. Is that correct?
Yes.
And if any inquiries are received by Legal Aid New South Wales relating to Aboriginal young people, are they directed towards the Custody Notification Service?
Yes, that's standard practice.
During your time at Legal Aid New South Wales in the Children's Legal Service, have you had shifts where you worked on the youth hotline?
I have.
Would it be correct to say that you've advised many, many young people on their legal rights in custody?
Yes, it'd be thousands of calls. Since 2011, I've averaged 2 to 3 shifts per month every year. Average of 10 or more calls. It's hard to say, but it would be in the thousands.
When you gave evidence at the private examinations and now, and in terms of the submission of the Legal Aid Commission to this commission, have you drawn on your own experience as well as the experience of other solicitors working within the Children's Legal Service?
Yes, and other, I should say, other solicitors working within legal aid generally. Not all of the solicitors who man the youth hotline are based in the Children's Legal Service.
I understand. Within the submission prepared by Legal Aid New South Wales are a number of case studies, is that correct?
That's correct.
Relating to actual young people who've been anonymised?
Yes.
Which draw out many of the issues that this commission is investigating. Is that right?
That's right.
With the Legal Aid Youth Hotline, in addition to speaking to young people, do solicitors also speak to support persons who are at police stations with young people?
They do.
And advice is given to those support persons about issues relating to them as support people as well as legal rights for the young person. Is
Yes.
that right? Perhaps to draw out the advice that you give and the information that you take from young people, what I'll have put up is the advice form, which is filled out. It's the form of a template on computer. It's an exhibit in these proceedings, which is MTS 90. The barcode is 8620259 to 0260. I wonder if that might be put up on the screen, please.
Yes.
Just ask you to look at the very top of the page first. Is this what a printout of the computer template would look like?
Yes, it's the first page.
So solicitors working with the youth hotline, when they're answering calls either at work or at home, have access to a computer, and when a young person, someone calls on behalf of a young person at a police station, this is the form that's filled out.
Yes.
Is that correct? What is contained at the top are a number of details relating to the advice, relating to the young person. Is that correct?
Yes.
And then if you go to the bottom third of the page, there are a number of details relating to the young person, such as what outcomes police are considering, what the situation is with bail, and the details of the support person. Is that right? Some of the details that you get from the young person include whether they live in out-of-home care. Is that right?
That's correct.
And whether the young person is in fact under arrest, and if so, what that's for. Is that correct? Just turning to the next page. About a third of the way, or in the top part of the page, there's a box that refers to speaking to the client. Is that a place where solicitors can type in notes or write in notes about the young person and what their details are and any additional information that they are spoken to about?
Yes, that's right.
About a third of the, right in the middle of the page, there are a number of boxes which contain information about advice on the Young Offenders Act, advice regarding the right to silence, and other advice. Is that correct?
That's right.
Does that form a guide as to the important matters that should be raised with the young person when you or anyone else is speaking to that child?
Yes, that's right.
Included in the right to silence advice is the following: an explanation of the right to silence, not doing a recorded interview, not going into an interview room, and no recording of a refusal on tape. Is that correct?
Yes.
In terms of instructions from the young person, you give advice to young people, and it's up to the young people whether they accept your advice or not. Is that correct to say? What you are able to do, though, is to note the instructions from the young person, such as wanting to admit the allegations for the purpose of a Young Offenders Act outcome, or offering a Young Offenders Act outcome but denying an allegation. Is that correct?
That's right.
What you note is also whether the young person wants to exercise their right to silence, whether the young person consents to you speaking to their support person, and whether the young person consents to you relaying their instructions onto police.
That's
Is that correct? In the very bottom part of the page is a heading referring to minor assistance, but of more importance is a box that relates to discussion with police. Is that right?
That's right.
Once again, that's a place where what you have is a guide to what you might raise with police as is relevant in that particular case. Is that correct?
That's right.
One outcome is for a recorded interview for the purpose of a caution or a youth justice conference.
That's correct.
Other outcomes, though, are exercising the right to silence and refusing an interview. Is that correct?
That's correct.
Another outcome is to ask the custody manager to note instructions in the custody management record.
Yes.
And a confirmation letter sent to police. Is that correct?
That's correct.
In order to do those things, do you get the consent of the young person first to do those things? In fact, it's referred to in one of the boxes that you get that consent.
That's right.
Is that correct? Those documents, that template that you have, assists you and any other solicitor who works at the youth hotline with the recurrent advice and procedures that pop up relating to young people in custody. Is that right?
Yes.
What you also do is you speak to the custody manager at the police station, as well as the officers in charge, if they are available. Is that correct?
That's correct.
Just in relation to the issue of children being placed before a camera to be recorded as to a refusal to give a recorded interview, are you aware of a police circular from March of 2005 in relation to that very issue.
Yes.
I'd ask for that police circular to be placed up on the screen. It's an exhibit and it's MTS 91.
Or was it
Sorry,
90?
90, I'm
90,
sorry.
yes.
MTS 90, the barcode is 8620261. This is a police circular which has the title Recording Refusals by Suspects to Participate in an ERISP, or Electronic Recording by Police. Is that correct?
That's right.
And just looking at the, this sets out in a document which was then in force called the Code of Practice for Crime, capitals CRIME, which was a document set out for police that, as you can see on the right-hand side of that document, perhaps we can focus in on the right-hand side column to the very first paragraph, please. This circular refers to the following in terms of admissibility of interview evidence, and it's this, quote, however, you do not have the power to compel or intimate to the suspect that they must participate in an electronic recorded interview for the purpose of recording their refusal. Record the refusal in your notebook and, if appropriate, on the facts sheet. Can you see that?
I can.
That protocol is something that's in fact referred to in the precedent letter that is sent to police after legal advice is given. Is that correct?
It is when, I should say, when the letter or email is actually sent.
When it's sent.
Yes.
I'm going to ask for that email to be placed up on the screen. It's an exhibit. It's MTS 88. The barcode is 8620257. I took you previously to the template advice. That allows you also on your computer system to generate a letter to be sent to the custody manager at a police station. Is that correct?
That's right.
This letter that's now up on screen is one used to confirm the instructions which have been relayed between yourself and the custody manager. Is that correct?
Yes, also sometimes the OIC or sometimes both.
If it's to both, would you send it to both? Would you send this email to both?
Yes, it's more, emails used more frequently than letters or faxes these days. So I think when it was first made, we were sending more faxes, but these days it's more likely to be an email than a fax or a letter.
What the email refers to is it's a confirmation of a telephone discussion. It confirms that the young person does not wish to be interviewed and will not provide any form of written statement. The young person does not wish to record his or her refusal to be interviewed electronically on ERISP or handheld voice video recorder or otherwise. Is that correct?
That's right.
You can see that after indicating that the young person wishes to exercise his or her right to silence, you make a note from the circular that I just read to you what is set out in terms of whether police have the power to compel or intimate to a suspect that they have to record a refusal on video. Is that correct?
That's right.
There's also a protocol that exists between Legal Aid New South Wales and the Commissioner of Police that was in force since September of 2004. Is that right?
That's right.
That protocol, which is referred to in the submission, makes reference to the operation of the hotline and the recording by police of interviews or the refusal to take part in an interview on electronic tape. Is that correct?
There is reference, yes, to that.
There is this circular, there is a protocol. What is your experience in terms of police and specifically whether after children have been given advice to exercise their right to silence, which is communicated to the custody manager and or the officer in charge, whether interviews still go ahead?
It's both my experience and the experience of the staff that man the youth hotline, that that interviews often still happen regardless of that advice. Or I should say regardless of those instructions being relayed to the police.
Is the way that you find out about that sometime afterwards when children actually come to court to with their police facts and they're talking to solicitors, getting advice about any charges they may have?
Yes, that's often the first time we find out.
If I can ask you to turn to the legal aid submission to page 9, please. What you refer to at part 4.2 there, under the issue of recording the refusal on tape, is that your experience is, even though these documents exist, it's the case that police still go ahead and put children in front of a recorded interview. Is that right?
Yes, that does happen.
And whilst they might say to you that the recording of a refusal on tape is your experience and the experience of others who work with you, that the interviews go beyond recording of a refusal, but the actual questions and answers, that is a full interview with those children.
Yes, that happens as well.
When you speak to police, are you given a number of different reasons? This is with custody management, the custody manager, as well as with the officers in charge, as to why police will put young people in front of a camera?
Yes.
What sort of reasons are you given by police as to why that is done, notwithstanding this protocol and this circular which are in force?
I guess common terms used, words to the effect of, in fairness to the young person, we'd like to put the allegation to them. It's my standard practice to have a refusal recorded. I've had instances where they say, well, I'm just going to turn on the body worn and have them say that. So they're all examples.
Have you yourself also aware of police saying, and this is recorded in the legal aid submission at page 11, that if the young person doesn't give the young person's side of the story, that police will have to charge the young person and they may not get bail?
Yes.
Have you yourself ever had that particular experience where you've heard that said, or it's been said to you?
Not in those terms, personally. My experience has been earlier having a conversation with police prior to speaking to the young person about bail. Often comments are along the lines of, when we're asking if they're considering bail or likely to give bail, comments along the lines of, well, it depends what they say.
What's set out in the legal aid's submission is a number of recurring issues that take place with custody managers and officers in charge. I've already asked you about some of them, such as the recording of the refusal on tape, as well as these other reasons why police give to explain why they put a young person on tape. I did take you to the template, and there is a box about requesting the custody manager to make a note in the custody management record. Is that correct?
Yes.
Of the advice that you've actually given to the young person and which you've relayed to the custody manager. What's your experience of whether that is in fact done?
It's difficult to say because we obviously don't have access to the actual custody management records. For the majority of times, the custody manager will say, yes, that's fine. Occasionally, you will get custody managers who might say words to the effect of, well, they're my records, I'll put in there what I want to, or words to those effect.
One of the issues that's been identified in the legal aid submission is that police facts are subsequently prepared and given to the young person, which do not in fact refer to the advice given to the young person that they not take part in an interview. Is that correct?
That's right.
How is it that you find that out when you're looking at a police statement of facts? How do you actually determine what the evidence, what the advice was that was given to the young person?
The only way we can do that is to check our electronic database for the actual advice. If it's a client that the Legal Aid Youth Hotline has spoken to, we can get a copy of the advice form and we can have a look at the notes made by the solicitor who was rostered on to see what advice was given.
I'll take you to some facts a little bit later on where what's noted in the police facts makes no mention of the actual advice given to children. Is that something that's fairly frequent as far as you're aware?
Yes, that's relatively common.
What about the situation about a change of mind by the young person? And what I mean by that is you give advice to the young person. It's up to the young person whether they follow your advice or not. But assuming the young person accepts your advice not to take part in an interview, is there scope later on, if the young person changes their mind, for further advice to be provided by the Legal Aid Youth Hotline?
Yeah, well, there's further scope, yes. We're always available to give further advice if required.
In your experience, how often has that happened, that a young person has decided to take part in an interview and police have actually contacted you on the young person's behalf?
It's not common at all. I can't recall a specific example when I was on the youth hotline where that's happened.
I took you to a protocol that you've referred to, which was between New South Wales Police and Legal Aid New South Wales from 2004.
Yes.
Have you or Legal Aid tried to update that protocol with New South Wales Police?
Well, we certainly are aware it needs updating.
Yes.
Yes.
Have you ever taken any steps, or are you aware of others within Legal Aid of trying to get that protocol updated?
Yes.
What steps have you taken?
We have, within Legal Aid, we have a updated draft prepared that we are happy with. The next step, I guess, is to sit down with police and see if they're happy with it.
Have you made steps to speak, to engage with police about the update to this memorandum?
Since I can't speak prior to me being in my current role, but we had a meeting with police in August 2019 where an update to the youth protocol was one of several, I guess, youth items on the agenda of a meeting.
It may very well be that there's some evidence later in this week by assistant commissioners about some priority that might be given to the updating of that protocol. Are you yourself aware of any recent steps taken by New South Wales Police to update that protocol?
I believe we might have received an email last week about perhaps sitting down and discussing with a view to updating it.
And who was the person who received that email? Do you know?
I'm not sure. I can't recall the exact nature. I just remember it coming through.
Someone
an email
within
chain.
Legal
Yes.
Aid New South Wales. I'm going to take you to the use of body-worn video. You've referred to it as one way of young people being recorded, although not on tape. I'm going to take you to an exhibit in in these proceedings. It's MTS 67, and it's an email between Legal Aid New South Wales and the New South Wales Police Force. Barcodes are 8543606 to 3608. I'm just going to ask for that email to be brought up. Just going to go to the bottom half of that first page first. And if that could be zoomed in on, please. This is, you're aware, an email sent between a solicitor at Legal Aid New South Wales and a police officer. And reading the text at the bottom of that first page, it refers to confirming telephone advice that the young person doesn't wish to be interviewed nor to provide a handwritten statement, and the young person didn't wish to have that refusal recorded either on ERISP, an electronic recording, or a handheld video, or on body-worn video. Is that correct?
That's right.
And if we can turn to the next page, to the page ending in barcode 07, you can see that the end of that email refers to the circular and to the direction to police about not having powers to compel. Is that correct?
That's right.
What you received, though, was a response to this email, and if we can go back to the previous page, please, ending in 06. What it says is the police officer wrote to the solicitor referring to the following, quote, "I appreciate your email. However, your understanding of the use of body-worn camera is not applicable to the information you have supplied," end quote. And it goes on to refer to this officer stating, as guided by legislation and New South Wales police policy, that he or she was allowed to activate the body-worn camera to record any refusal to be interviewed. Can you see that?
Yes.
Without going through the text of the rest of the email, which is an exhibit in these proceedings, what the officer has said is that if they wish, they will use their body-worn camera and activate it to record a refusal. Can you see that?
I can see that.
Is this something that you've experienced frequently, about the use of body-worn video?
Yes, it's not uncommon. Emails to this effect, I can't remember any more than that, but it's more likely to be in a conversation between the police officer and the lawyer on the telephone.
What you have done, Mr. Frankham, which took you a considerable amount of time, is in order to give evidence before this commission, you've gone back over a number of records kept by the solicitors from the Legal Aid Youth Hotline. Is that correct?
The files are from the Children's Legal Service based at Parramatta rather than the Youth Hotline files.
And you've looked at the physical records of advices as well as police facts that relate to those advices. Is that correct?
That's right.
And in that way, you were able to compare the advice given to children with the outcome, which is set out in police facts. Is that correct?
That's
in
right.
fact, you've got many such advices, and you've spent a number of hours going through to pull out examples to illustrate the issues that we've just been discussing. Is that correct?
Yes, that's correct.
Just on this issue of body-worn video, I'm going to ask for a document to be put up on screen. It's MTS 86. The barcode is 8620251. This is a one page from a statement of facts which has had information taken out, which is identifying information. This was one example that you came across where you looked at facts and compared it to the advice given, and you made a note of how body-worn video was used in a different way to an electronic recording. Is that correct?
That's right.
What you noted, which is contained on these police facts, is that the child in this case was given legal advice, and actually doesn't refer to legal advice in this extract, but it refers to the child declining to take part in a recorded interview, but in fact being interviewed on body-worn video. Is that correct?
That's right.
And if I just read directly from the facts, it says relevantly, however, when questioned about the incident on body-worn video and shown CCTV stills, end quote, the young person went on to provide some information. Is that correct?
That's right.
That was one example of a number of examples that you had where, although a child hasn't been put in front of a recording machine, they've been questioned on body-worn video. Is that correct?
Yes.
I'm going to take you to another example which you've provided. This is exhibit MTS 85, and it's barcoded 8620250. We can just zoom in a little bit. In the top paragraph on that page, there's reference to police speaking with the young person in an interview room and the young person giving police some information. And then what you can see in the third paragraph is police offered the young person the opportunity to take part in an interview which the young person accepted and then made admissions. Is that correct?
That's right.
Having these police facts, you then cross-reference these facts with the actual advice given to the young person. Is that correct?
That's right.
And what did that advice indicate?
I can't go into exact detail in terms of all of it because of privilege, but I can say that the young person gave permission to speak to police and to relay to police that he wished to exercise his right to silence and not have his refusal recorded.
I should have been more specific. Just in relation to that aspect, did the advice show the young person did not wish to speak to police? Even though that, is that correct?
That's correct.
Even though that advice was given, these facts make no reference to that advice. Is that correct?
That's correct.
And the young person was, in fact, interviewed. And there is a part of the legal aid submission to this commission which refers to police facts which don't completely contain all the relevant facts, including the advice given to young people. Is that correct?
That's correct.
This is one example of that being the case. Is that right?
Yeah. I should just clarify in terms of the advice that it's specific to the advice where instructions have been relayed to the police that they want to exercise those rights. That's what's missing.
Yes. I'm going to go to a exhibit MTS 91, which is barcoded 8620362 to 8620363. This is a redacted statement of facts. This was a police statement of facts provided by yourself on behalf of the Commission relating to a child who had been placed under arrest, and as noted at the very bottom of that first page, the child spoke with youth legal aid, that's the Children's Legal Service, is that right?
That's right.
And then turning to the next page, what it indicates is the child participated in an electronically recorded interview and was later charged. Having provided that part of the police facts, did you go back to the actual advice given to the child?
Yes.
And relevantly to the questions that I've been asked, and not asking you to waive privilege or anything else, what did that advice indicate?
That the young person wished to exercise their right to silence, and they wished those instructions to be passed along to police, and it was indicated in the advice that that occurred.
What these facts show is, firstly, none of that's recorded in these facts, is that correct?
That's correct.
And secondly, even though that was the advice which was passed on to police, the interview went ahead regardless.
Yes.
Is this something that is you've come up, it's an experience it's not uncommon, it's something that frequently takes place?
Yes.
Your evidence is that there are police who do follow the appropriate steps, and when children don't wish to be interviewed, they don't interview them. Is that correct?
That's right.
However, there are these recurring issues where that's not taking place. Is that correct?
That's correct.
I'll take you to exhibit number MTS 92. This is barcoded 8620-364 to 365. This is a statement of facts, which if we can just zoom in on the bottom of the page, please. This refers to police speaking to a young person, cautioning the young person, and then taking that young person back to the police station and reading the young person's rights in the presence of the support person, and then speaking to the Children's Legal Service. Is that correct?
That's right.
And then just turning to the next page. The facts refer to the young person being offered the opportunity to take part in an electronic interview, which the young person accepted, and which was also accepted by the support person. Having seen these facts, did you go back to look at what the advice was that was given to the young person?
That's right.
And relevantly to what we've been discussing and not disclosing anything that doesn't need to be disclosed, what was that advice?
In a similar fashion to the last matter, it was a matter where the young person wished to exercise their right to silence. We received permission from the young person to relay those instructions to police. Those instructions were then relayed to the police.
Is it correct to say that you're finding out about police conducting interviews, even though the advice has been relayed that there would be no interviews, really at the time that children are coming to court and showing you facts, which you're then checking against the advice given?
Yes, although we don't check it in every occasion because sometimes it's not an issue that needs to be raised.
Do you yourself have experience in challenging the interviews in the circumstances that we've been discussing in hearings in the Children's Court?
Yes, not recently, but several years ago, yes.
What about young people? Are they always wanting to challenge the admissibility of these interviews?
No, it's my experience that it's more common for them not to want to challenge the
Have
admissibility.
what are they saying to you? What are the words they're using as to why they don't wish to challenge these interviews?
There are all sorts of reasons. Often the interview by itself, or there's other evidence in addition to the interview. Often, if it's the only evidence, a young person on bail who's been advised, for example, that their likely penalty might be a good behaviour bond, they will often say, well, I'd rather my matter over and done with and not be on bail for an extended period, to have the matter determined by a court in circumstances where they may not be successful. That's not uncommon.
These issues relating to young people and interviews with police, are these issues that you have encountered for all of your time at the Children's Legal Service?
Yes,
Do they continue right up until now?
they do. I should say the use of body-worn video, though, has become more prevalent in the last 3 to 4 years. Prior to that, it wasn't used as often.
When you say body-worn video has become more prevalent or its use, what do you mean by that as they relate to young people?
As it relates, yes, to the use by police, it's often used by police to take admissions for a Young Offenders Act diversion, for instance. I think it's very easy for the police to just turn on the recording, take some admissions and turn it off, and it's becoming more common to question them in terms of their investigation.
The children aren't actually put in front of the videotape, but they're recorded in these other ways. Is that right?
That's right.
Even though the template letter that you send to police makes clear that they're not to be recorded in any way, including through a handheld or other device. Is that right?
Yes, when those letters or emails are sent, yes.
That completes my questions, Chief Commissioner.
Could I just ask you a couple of things? When, withdraw that, what you've described helpfully to the Commission is all a process of advice and communication by telephone.
Yes.
And that reflects the practical reality that there are people in police stations all over the state at any time who are being arrested and maybe going through the processes which you've been discussing.
Yes.
Is it still the situation that perhaps during the working daytime, if there's interaction with the police, that there may be a legal aid solicitor at the police station who may be able to talk face-to-face to the police about these sorts of situations? Or is the practical reality that it's pretty well all done by telephone now?
It's all done by telephone. I can't recall an example of a legal aid solicitor appearing in person at a police station.
I suppose the legal aid solicitor is likely to be at the courthouse rather than the police station on any sitting day, certainly.
Yes, normally when they're rostered on for the youth hotline, they're normally not rostered on court at the same time. So they're normally during the day either in the office or they're since COVID, more likely maybe to be working from home.
Yes. In circumstances where all the communications are being done by telephone or email rather than seeing what's happening, I take it that you're not in any position to say whether the police at the police station, who may be saying they want to use body-worn video to record something, are in uniform or in plain clothes.
Yeah, I couldn't say.
Thank you. And,
Nothing arising. Thank you, Chief.
does anyone want to seek leave to ask any questions of Mr. Frankham?
Yes, Chief
Yes,
Commissioner.
yes.
Afternoon, Mr.
All right, leave granted, yes.
Morning. Just based on your long-term experience at Legal Aid in the Children's Unit,
Could I just ask you to get a microphone a little closer to you? Thank you, Ms Lee.
is
Right,
that
yes.
better, Chief Commissioner?
Yes, I think so, yes.
Just in relation to your experience at Legal Aid in the Children's Unit, for you and your experience, what are the particular vulnerabilities pertaining to young people in custody?
There are many vulnerabilities. It's hard to describe it briefly. They often have very limited experience with the criminal justice system and being in police custody. A lot of them have difficulties understanding not just legal advice but the process at the police station. And whilst they're often supported by support people, it's often the case that the support person themselves, if it's a family member, often isn't in much of a better, I guess, situation than the young person. So their particular vulnerabilities, they're often scared to speak to the police about what they want or whatever it may be.
And would you say there is a power imbalance between the young person and the police?
Yes.
And in terms of young people in regional areas, do you think there are some particular vulnerabilities for those in regional areas?
I think so, to the extent that regional areas often don't have the same level of support services that are available in metropolitan areas. And whilst that might not factor in at the particular time at the police station, there might be, for example, youth workers available in the metro areas who might be able to attend to assist the young person, that have a long-lasting relationship with that young person. Often the young people in regional areas don't have the benefit of those types of support services that can really assist while young people are at the police station.
Yes, thank you. And then also for children who are First Nations background, are there any particular vulnerabilities for those children?
I would say yes. Again, a lot of them, in my experience, are from those regional areas and regional towns where there's a lack of any type of support services. They often have a long history, unfortunately, a long history of interacting with the police. And not just the young person, but their extended families.
Thank you. In terms of your evidence that you've given about sometimes police don't adhere or allow the young person to implement their instructions from you, is there any legislative change you think would assist with strengthening the rights of young people in custody in regards to that particular issue?
Yes, I think if it's made more clear about what the obligations are on custody managers and officers in charge of investigations, where it's made particularly clear what they are allowed and what they are not allowed to do in terms of young people and interviews. I think it needs to be set out in plain language, and so that there's no room for miscommunication or misunderstanding.
And do you think training would be sufficient to deal with these issues that have been raised today by you?
I think it would be beneficial, but in and of itself, I think it also needs to be backed by other measures.
Just a couple more questions, one around body-worn video. When body-worn video footage came in, did you see it operating in this way as being a tool for collecting or undergoing interviews with children?
No, that's not how we originally viewed it. I think my experience was it was to be a good thing if it was, I guess, recording interactions between young people or adults or any other person in the police. But it seems to have, I guess, unintended consequences.
Do you think it's being used to supersede the need for an arrest?
Yes, in circumstances, yes. Or I should say, in my experience, yes.
Have you heard of, in your experience, of body-worn video footage being used to identify children?
Not my direct experience, but I have had staff within our team speak about young people being identified on body-worn video, normally used to, I guess, take a video of the young person shortly after an alleged offence that might match a description or CCTV in terms of clothing or other identifying marks.
And would this be for children under 14 years as well?
I think children of all age groups from 10 to 17.
If that's the case, do you think the Forensic Procedure Act comes into play in these circumstances?
I think we're moving into an area where there might be an opportunity for the Legal Aid New South Wales to make submissions on these things. So I think entering into the Forensic Procedures Act is a little beyond the scope of what we're doing now. It may be a matter for submissions in due course, or possibly even questions of police officers. But if we could keep a little closer to the mark as to the subject matter for which Mr Frankham has been called. Now, it's after 1, Ms Lee.
Yes,
How much longer are you going to be?
Yes. Can I ask 2 more questions
Sure.
to the Commissioner? I just turn now to the use of force, which is also part of this, these examinations. In your experience, have you represented children where force has been used against them for fine-only offences?
I can't recall specific examples. I couldn't say one way or another.
Yes, thank you. And in your experience, when force has been disclosed by the young person, is it reflected in the fact sheets by police?
It's been my experience when, several years ago when I was practicing, if an issue of excessive force came up, in terms of admissibility or otherwise, it often wasn't included in detail in the fact sheet.
Thank you. That concludes my questions. Thank you.
Does anyone else wish to seek leave?
Chief Commissioner, I had 2 questions, but your first question covered the first question, so I've just got one other issue just in relation to the MTS 89 and that sheet, and as to whether there's any distinction between the ages from 10 to 18, and just lastly, what training, if ever, the members receive in relation to the understanding of the young person on the other line.
It's almost 1:10. It's necessary for the Commission, for other purposes, to adjourn now, but we'll resume at 2 p.m. if that's convenient. If you'd like to step down for the moment, thank you, Mr Frankham, and your evidence will continue at 2 o'clock. Yes, the Commission will adjourn till 2 o'clock.
Stand.